This video is for educational purposes only and does not constitute legal advice. For advice about your specific situation, please consult a licensed attorney. Parts of this content were created with the assistance of AI.
What really counts is negligence. It's not just about accidents, it's about the duty we owe to each other, the choices we make, and the risks we create. In this video, you'll see how the law decides whether someone acted with reasonable care or crossed the line into negligence.
Welcome back to Legal Matters Radio. I'm your host, Sarah, and today we're diving into an important topic in civil law, negligence. To help us understand it, I'm joined by Professor David Johnson, an expert in tort law. Professor Johnson, thanks for being here.
Thanks for having me, Sarah. It's a topic a lot of people hear about, but don't always fully understand, so I'm happy to explain.
Let's start simple. When courts in California look at a negligence claim, what are they considering?
Well, generally, there are three things to show. First, the defendant was negligent. Second, the plaintiff was harmed. And third, the defendant's negligence was a substantial factor in causing that harm.
Okay, and how does California define negligence exactly?
The California Supreme Court in Ladd versus County of San Mateo put it clearly. The elements of a cause of action for negligence are well established. They are, first, a legal duty to use due care. Second, a breach of such legal duty. And finally, the breach as the proximate or legal cause of the resulting injury.
So it's really about duty, breach, and the resulting harm.
Exactly. And that first element, duty, may be imposed by law, be assumed by the defendant, or exist by virtue of a special relationship. That's why some relationships, like doctor-patient or teacher-student, carry extra responsibilities.
Makes sense. But how do courts decide what counts as reasonable care?
Good question. Courts consider that a question of law first, as Ramirez versus Plow explained. The formulation of the standard of care is a question of law for the court. Once the court has formulated the standard, its application to the facts of the case is a task for the trier of fact if reasonable minds might differ as to whether a party's conduct has conformed to the standard.
So the court sets the standard, and then it's up to a jury or judge to see if it was met.
Exactly. The Restatement Second of Torts also helps explain this. Section 282 says negligence is conduct which falls below the standard established by law for the protection of others against unreasonable risk of harm. Section 283 adds that unless the person is a child, the standard is that of a reasonable person under similar circumstances. And Section 284 notes that negligence can come from doing something wrong or failing to do something you should have done.
So it's not just about actions, but also inactions.
Right. And the California Supreme Court in Flowers versus Torrance Memorial Hospital emphasized that the amount of care is situational. It changes depending on the circumstances, but the standard itself, due care, stays constant. Courts may also rely on statutes or prior judicial decisions to settle what's reasonable.
That helps put it all in perspective. So negligence really is about context, the duty involved, and whether conduct matched what a reasonable person would do.
Exactly, Sarah. It's always about the specific facts, the risk involved, and the relationship between the parties.
Professor, thank you for walking us through that.
Glad to be here.
And to our listeners, stay tuned for more discussions about law and how it works.
Quiz time. Here's the question. In California law, what three things must a plaintiff prove to establish a negligence claim? A, duty, breach, and resulting harm. B, intent, motive, and damages. C, contract, agreement, and breach. D, risk, warning, and responsibility. The correct answer is A, duty, breach, and resulting harm.
Don't forget to like and subscribe. It really helps us create more educational content like this for you.